I'm going to introduce you to the Jones family. There's nothing particularly special about the Jones family. They live right down the block from wherever you live, and they have an estate worth $700,000. Now, you might be thinking, wow, that's so much, that's a ton. Or you might be thinking, okay, I've got more than that. Well, this is $700,000. That doesn't just mean a bank account with $700,000 in it. That means all of their accumulated assets, their house, their car, everything, altogether is worth $700,000. Now, you might also be saying, well, this isn't going to apply to me because I'm not married, or I'm widowed, or divorced. Well, again, as you'll see moving throughout, this still very much applies to you, so stay tuned. Like many families, the reason that Bill and Mary care so much about planning their estate properly and doing a good job is, of course, their two children, John and Susan. Well, just a quick background on John and Susan. They're two very different children, as are children in many families. And John, he's the troubled child. He's had a tough time in school. His friends are not the type of friends that most parents want their kids hanging out with. And he gets involved in drugs and alcohol as he's going through life and hasn't really been able to hold down a job. His parents, Bill and Mary, still love him very much. They're still in close contact and try to help him as much as possible, but he's the troubled child. 100% different, we have Susan. She is the perfect child from day one. She excels in school, is the teacher's pet, the class favorite, wins all the awards, and is currently a very successful CPA and married with children. So we have a pretty common family with two very different children. Here are Bill and Mary's current estate planning options. And the first option that, unfortunately, I think due to a lack of education, a lot of people choose is, I'm just going to spend everything I have. I'm going to take as many vacations as possible. I'm going to drain the bank accounts before I go because I don't know what's going to happen after I go. And that's really option number one. After that is option number two, which is called dying intestate. Dying intestate is a fancy legal word just to mean that you die without any real planning in place. You die without a will. You die intestate. And you don't have to necessarily get rid of all your assets and spend them off, but if you die intestate, the court is going to just distribute everything according to the state statute, as opposed to how you would want the assets to be distributed. So that's really their second option, is to not spend everything, but die without any planning. The third option is they can just have title to all of their assets in what's called joint tenancy, which I'm not going to get in here too much, but just take away from this that if you currently own your assets in joint tenancy or you plan to, this is certainly not the best estate planning tool of how to own title to assets. The fourth option is a step above, and they can create a simple will, which will achieve the goal of distributing their assets, but as we'll see throughout, will fail to give them the full protection. And 5 and 6 are, of course, the trust options. 5 would be creating a bare bones trust, which is just a trust that's straightforward, none of the special options that we can add. And finally, their best option would be to create what is called the Family Wealth Trust, or a revocable living trust. And we'll get more into that, but that really is what we advise to most of our clients and is the best option and gives the most protection, flexibility, and options for the common family. So that's Bill and Mary's options as they stand today with their two children.